Welcome to Authentic Ingenuity Entrepreneur. My name is Minna Crichton. My employer is where everything started. So the employer in this case is the Ministry of Justice. These are the charges that I've actually chosen. It's a very clear criminal case. Overall, it is a trafficking in persons case because of the evidence. Now, trafficking in persons has the penalty of 20 years imprisonment. So I've actually researched the laws, and this is, I would say, probably the biggest penalty for a Crimes Act for any crime. There are others, but just for trafficking in persons case, it is a 20-year penalty. So those are the charges that I have on the statement of claim, and that is what I'm suing my employer for. So my statement of claim and notice of proceeding against my employer was first lodged on the 9th of February 2023. Now, the counsels for this case was Meredith Connell. Counsel's first submission was on the 19th of May 2023. What they had put in response to the notice of proceeding and the statement of claim dated the 9th of February 2023. So it's an interlocutory application to strike out statement of claim dated 9th of February 2023. And along with that, they had submitted an affidavit of Sean Graham Hayward in support of application to strike out statement of claim dated 9th of February 2023. So those are the two applications. So what I need you to kind of like keep in mind and focus on are the dates these applications are being submitted to court. There's a reason for that. And so my statement of claim was officially processed by the courts on the 9th of February 2023. Instead of when I first submitted it with the judiciary review. All this is important, and you'll see why, because everything links. So with that, I was just finished doing another court case, and I knew that this had come through, but I did notify the courts that I was currently, working on other applications to do with another civil case, which was the Ministry of Health and City Med. So when this came through, I was still working on other applications. Against the the defendant for the Ministry of Health and City Med. But I did notify the courts that I had made a decision that I was going to put in an interlocutory application to enter a summary judgment of liability. So these applications takes months to put together. Some of my applications have taken up to 3, even 4 months, depending on the circumstances. Circumstances change all the time. That's how long some of these applications can take. I could have minimized that, but my circumstance during the time when I was dealing with the Ministry of Justice case, the circumstances at home was different, so it was quite difficult to get into a routine. And yeah, it involves a lot of research and just concentration, just putting a document together. So with that, that is the council's first application on behalf of the defendant. Then in between, around about the 20th of July, the councils initiated a case management conference. But I hadn't, my application that I had been working on, because of all the other cases I was working on, I had to kind of put that on hold. So that was a setback, but the courts were aware of it. So I did notify them. So on or about July the 20th, the councils made submission and wanted to do to initiate is the word. They initiated a case management conference, which is the first hearing for this case. However, that's not how it usually is, and this is the new system. Those that come from the old system, like I have, this is the new age system. I didn't know about it till I actually went through it. So with that, I quickly respond in memorandum and let the judge know my circumstance at the time, that I was currently working on a interlocutory application. I notified the courts, according to the law, this is what should be going on, this is how it should be, keeping in mind the courts aren't making it anything easy for me. They've quite obviously sided with the defendant. So my case is already prejudiced and biased, and I'm basically up against a lockout situation or blacklisted situation. So I did let the courts know that this is not the proper avenue or the proper route of how it should be. And I already had it confirmed by other case officers who had actually moved on to another job eventually. But so with that, I put in a memorandum to the judge. By this time, the councils were charging me for $10,238 in costs for their costs. So they were charging me the fee on top of to strike out my claim. So I put a memorandum forward in response to the council's initiating case, what's it called? A case management conference. This is the first hearing for any cases. This is the court protocol, and according to the laws, this is what's supposed to happen. I put in a memorandum and I let the judge know that I'd already notified the courts in regards to this case, and the courts are very well aware. I had other courts and I'm representing myself, and so I'm hard out working at home, putting all these documents together for the other cases, but I did let them know that I will be working on my submission in response to the Ministry of Justice case. I put that memorandum in, and of course I disagreed about paying for their fee, and with that it went the memorandum and council's application to initiate case management conference hearing. The judge had a look at it, and the judge allowed me time to finish my application that I was working on. Notified the judge, and I notified the courts that I was doing an application called an interlocutory application to enter a summary judgment on liability, and so that's the application I was working on, and along with that I had was also submitted other documents with this application. So that was, I just let the judge know that is my intention, that is what I'm working on, and I needed more time. But my application wasn't ready, but they wanted it to get it started. So with their application and my response, it went before Associate Judge Brighton. So the submissions went before Associate Judge Brighton, and he made a minute on the 26th of July 2023. Okay, so judge had actually set a hearing date, which was the 1st of November 2023, and he had set down an official hearing date for this case to be heard at the High Court. So judge actually granted my time for me to be able to, the judge granted me time to finish my application, and then he gave us a schedule which we had to abide to and work along with. So he gave me a deadline of the 25th of August 2023 to finish my application, and then the defendants had to respond to my application on the 11th of October 2023. And so the judges set those hearings. And then the plaintiff, which is myself, I had to respond to those applications on the 25th of October 2023, and the actual hearing was 1st of November 2023. So that's the judge set us a schedule. It is a new age system. I didn't even know this existed until I had to go through it myself. I think it's vital that I get the details right, because the evidence speaks for itself. And a lot of it, I didn't see it until I actually put it myself together.